Hello, everyone. Thank you for joining me today. My name is Sasan Mirkarimi. I'm a managing partner at Equity Legal. And today we're going to be talking about foreclosure in a series of our Protect Your Equity um, sit down discussion. And in our last episode, we talked about the various different options to avoid foreclosure. And today we're being asked a very, very important and difficult question to answer. How long can I stay in my home? Um, this is a very common question that I get from my clients. Each time, they contact me and we sit down for a consult, it's the first one that comes out of their mouth. How long can I stay in my home? Well, there are a lot of different factors that will affect how long that can be, and we're going to touch on those today. And of course, like I've said in my previous sessions, this can be a very, very thorough, very long uh, episode, just talking about answering the various different ways that you can stay in your home longer. But we're going to go ahead and just kind of generally touch the surface of the common things I've seen in my experience. And I would like to note as a legal disclaimer that I'm not providing specific legal advice to anyone's specific question as to staying in their home longer. And so please note that. However, we will touch on the various different, the key points that I've seen in practice where you can potentially stay in your home longer. And so why don't we get to them? You'll see here some items of consideration. And like I said, unfortunately, there's just not a clear-cut answer or time frame. Why do I say that? Well, because there are a lot of attorneys and other professionals or non-professionals that will come at you with some big guarantees. You're going to stay in your home as long as you want, minimum 2 years, minimum 1 year. Anyone that's doing that, I would question it. I would question it because there's no such thing as guarantees, unfortunately, because there's a lot of moving factors. You've got a bank that's trying to foreclose on its asset that's going to move swiftly. You've got court process. You've got judges. You've got juries. You've got, the wrong professional. Hopefully, not in your case, but it happens. You've got scammers coming at you, trying to prey on the situation you're in. So there really isn't a clear-cut answer or time frame, and a lot of people that provide that are just trying to get your business. So just be cautious, ask questions. When they give you that guarantee, ask them how and why. We'll get into some of that as to how you can do it the right way. And again, that takes us to point number two. Anyone that tells you that is most likely trying to scam you. Is that always the case? No. But it's just something to be wary of because I've seen that in practice a lot of times. I've got clients that unfortunately that was promised to them and then they were just in a much worse position. Now they've either had their house sold from underneath them, the person or the professional, or even sometimes, unfortunately, the attorney that promised them that is now long gone and they're sitting here in a very vulnerable situation. And luckily we've been able to help them, but it just makes things much more difficult for them. So just be cautious of that. So let's get into kind of my 90-20 rule. This is what we write here is Equity Legal's 90-20 rule of thumb with respect to an actual time frame. And it's actually linked to what the legal requirements for foreclosure are. So it's a nice baseline to provide the client each time they come into my office. So what is the 90-20 rule? Well, foreclosure itself is initiated in California by the filing of a notice of default. In California, we're a non-judicial foreclosure state. So what that means is it's carried out by a third-party trustee, and it's a statutory framework that actually governs the process itself. It's not a court procedure. It can be, but 9 times out of 10, it's going to be the non-judicial process. So, and within that process, once that notice of default is recorded, the servicer bank has 90 days before they can then issue and record what's called a notice of sale. Now, the notice of sale is what actually sets forth your sale date, the place of your public auction of your property, the time, and the date. And so when I say 90-20, I'm referring to the fact that once the notice of default has been recorded, the bank cannot issue the notice of sale for 90 days from that point. Once that 90 days is expired, then they cannot set a sale date less than 20 days from that point. So 90 plus 20 is what's going to give you the 110, kind of guideline, or let's just say baseline for the time period. And again, that's assuming the bank is going to move swiftly. So what I tell my clients is the 90-20 is the time period that they can potentially foreclose on you. Now, how do you avoid that? How do you stay longer? That's the next question. So really, that it depends on multiple different factors, mainly the type of circumstance that got you to foreclosure to begin with and where you are in the foreclosure process. So a lot of times I've had clients that were very proactive. Let's say they were negotiating a loan modification. And again, that's one of the options we discussed in our prior session was a loss mitigation or loan modification or short sale, one of those options. When that's presented to you, you basically are staying ahead of the deal. And if you're aware of the foreclosure itself, you're trying to do a workout. Well, I've got a lot of circumstances where the workout didn't work out like it was supposed to. And now you've got a client sitting here with a sale date. And so what's their recourse? They've got to file suit. Now, the suit can be filed for many different reasons. And again, that's a topic we would have to discuss when we thoroughly examine your case, because it could be anything from irregularities in this foreclosure process itself, not following the statutory guidelines. It could be fraud, just straight fraud. The bank employees or representatives promising you one thing but actually doing something else. Hard to prove, but it has happened. I've seen it, and we've gone after the bank and recovered very high settlements because of it. Even just being negligent, being careless, not processing your paperwork on time, and then kind of just not mentioning to the client that there's a foreclosure that's happening and there's a sale date, but at the same time you have another member of the bank telling the client, where we need more information before your loan modification is approved. Hang tight, we're going to help you. That's the most common thing I'm seeing litigated now, even though after 2008, 2009, after the foreclosure crisis that occurred, California has certain guidelines and regulations that prevent what's called dual tracking. And that's the circumstance where the bank is actually, on one hand, foreclosing on you, and on the other hand, supposedly trying to help you on a loan modification. That is the most litigated type of situation that I've seen my clients in when they're in foreclosure. And when that's the case, it's filing a lawsuit is almost the only remedy to get ahead of that. Both statutorily, you have rights and the rights to recover attorney's fees, but also you can then, when you file the lawsuit, you can get a restraining order. And when you get a restraining order, that actually puts the foreclosure on hold. So that is the key, putting the foreclosure on hold. And our topic today is about how can I stay in my home longer? So the best way to make that happen and make that happen for as long as possible is to get that restraining order and get the court to give you an order preventing the bank or any of its agents or trustees to be able to foreclose while you are actually affirmatively pursuing your legal claims in the court action. This is a very important thing that we do, and we move carefully. And when not done carefully, you can lose that right. So you might have a lawsuit in one hand, but you can't stay in your home. So now you're just trying to throw money to trying to collect monies. But in the end of the day, I would say majority of the time, the client's first goal is to save their home and stay in it as long as possible. So we've been very successful when the client comes to us early enough to stay ahead of this and fully assess their issues, and then be able to, get them in the position of filing the lawsuit, getting a restraining order, and to the point where we've seen that take, 2 years, 3 years, as long as the court process takes to get their favorable, ruling before a judge or before a jury or even a settlement. So, on the flip side, when done properly, when you retain an attorney like ourselves and you're on top of it, there is light at the end of the tunnel. There's hope, because the court process is meant to protect you, and it can when navigated properly. So, that can take as long as you need to save your home before you have your favorable day in court. So on the short end, the baseline, the 90-20 rule, and again, if when done correctly, it could be as long as you need, so long as you have, valid legal claims and they're properly being pursued in court. So we can get into that in more detail as we go forward. But for today's purposes, that's really just kind of that question, how you can be taken advantage of when that's raised, but also how you can use that in your favor and seek the right guidance. And by talking about that, I'd like to point out that we do offer free consultations. So if you're in foreclosure, you are pondering that question, you've been served with a notice of sale or notice of default, and you don't know where to turn, we do offer free consults, 15-minute consult to talk about your your specific situation. And then what I've seen be very helpful for my clients, even pre-foreclosure, is our strategy session, where we actually can review your documents, look at anything from the start of when you got the loan to the point of how it was handled through foreclosure, and then try to work out what the best option is for you. And if it is court action, then we move pretty quickly on getting that restraining order and filing the lawsuit. So that is something we do offer our clients. Feel free to check out our website for more details. Thank you very much for joining me, and I look forward to talking to you on the next topic regarding foreclosure.